Welcome to this event, the title of which is Crisis at the Justice Department, Perspectives on Prosecutorial Independence and Political Interference, which is co-organized by the Reese Center on Law and Security and Just Security. I'm Ryan Goodman, one of the faculty members here at NYU, co-director of the Reese Center and co-editor-in-chief of Just Security. We think of this basically as an emergency event. If we're not going into a constitutional crisis, at a minimum it looks like a crisis for the Justice Department. And we couldn't think of three better panelists to convene at a moment's notice, in a certain sense, around this idea, and the fact that they're all here also gives you a sense of the gravity of the situation. So I'll just say a few words of introduction about our speakers, and then I'm going to do a bit of the nuts and bolts just to give us a timeline so that we're all on the same page, and then essentially turn it over to them with some questions. Then we'll have time for questions from the audience, first from NYU students who have questions, and then others. And there should be no video or audio recording of the event, but the Reese Center will make the video available. So just to say a few words about our speakers who, in some sense, I was ambivalent about introducing them because they really require no introduction, but just from my right and then further to the right. First is Bob Bauer, former White House counsel to President Obama. I should also say all three are professors at NYU and distinguished senior fellows at the Reese Center on Law and Security, and we're extraordinarily grateful to have them here in our community and teaching our students and as colleagues. So Bob Bauer, former White House counsel to President Obama. Lisa Monaco, former Homeland Security advisor to President Obama and senior Justice Department official in the Obama administration as the Assistant Attorney General, and also in the Justice Department for the George W. Bush administration and in the Justice Department for the Clinton administration. And Andrew Weissman, former General Counsel for the FBI and former Senior Special Counsel for the Special Counsel Robert Mueller for the Robert Mueller investigation, and also Chief of Fraud Section of the Department of Justice in the Trump administration, and served in the Obama and Trump administrations, as well as the George W. Bush administration and the Department of Justice, just to give you a sense of the span of these extraordinary individuals' careers that are not about serving one particular party, but rather the country. So the basic background is just the nuts and bolts of what's gotten us here, which is primarily the Roger Stone trial and sentencing, and then we'll broaden the aperture, I'm sure, during the discussion to other connected events surrounding the Department of Justice and Attorney General William Barr. But the Roger Stone trial is really the focal point that generated this event, and he's by way of background, a longtime associate of President Trump. I believe it dates all the way back to 1980 when Roger Stone and Paul Manafort first set up their lobbying shop in Washington, D.C., and Roger Stone has said that his first client in 1980 was Donald J. Trump. And then over the years, he also has always been a kind of an informal advisor, but became a formal advisor and then dropped off and was an informal advisor to the Trump campaign in 2016. The case against him was a spinoff from the Mueller investigation, in which the Mueller team handed off the case of Roger Stone to the U.S. Attorney's Office for the District of Columbia. He was charged and then convicted on November 15th of 2019 for 3 charges: lying to Congress, obstruction of the investigation, and witness tampering in terms of threatening a witness with physical injury. And his lies to Congress involved statements about his connection to WikiLeaks and knowledge of WikiLeaks document dumps in the 2016 election, statements like that. The sequence of events that happened just in the last couple of weeks, few days, is on February 10th of 2020, the prosecutors in the case submitted their recommendation for sentencing to the judge within the sentencing guidelines, recommending 7 to 9 years imprisonment. That was at around 6 p.m. on February 10th. On February 11th, right at 1:48 a.m., the president tweeted, quote, "This is a horrible and very unfair situation. The real crimes were on the other side as nothing happens to them. Cannot allow this miscarriage of justice, exclamation point." That was at 1:48 a.m. That morning, the Department of Justice told reporters that they were revising the recommendation. Around 3 p.m., the fire alarm began, and fire alarm, as even like legal scholars and academics refer to this, resignations started happening. So the 4 prosecutors on the case withdrew from the case, and one of them resigned completely from the Justice Department. He was Jonathan Kravis, the Deputy Chief of the Fraud and Public Corruption Section of the U.S. Attorney's Office of the District of Columbia. I thought to quote from a piece written by Lisa Monaco at Just Security in the past few days, in which she said, quote, "A prosecutor withdraws from a case if and only if she believes she cannot in good conscience proceed. This high threshold is met only when, as an officer of the court, you cannot stand up and say the words that every assistant U.S. attorney beams with pride is saying, I am here on behalf of the United States Justice Department. I represent the United States in this matter. If you cannot stand up and in good conscience advance the position of the department, you have no choice but to withdraw and sometimes to resign altogether. That's how serious this is. It is a fundamental question of who and whose interests you serve," end quote. At 4:45 p.m., after these resignations started happening and the withdrawals, the Department of Justice, Washington, D.C. office submitted a new brief in which they no longer called for 7 to 9 years in jail. They didn't specify an amount of imprisonment or years. They just asked for leniency and said that the current amount of 7 to 9 years might be disproportionate, and asked the judge to take into account Roger Stone's age and health. On Wednesday, the next day, the president, in a tweet, congratulated Attorney General Barr for taking charge of the case. Attorney General Barr then gave an interview on ABC News in which he acknowledged that he was directly involved in the decision to resubmit the sentencing proposal, and he criticized the president, saying that the tweets by the president were not helpful for him to be able to do his job. The judge in the case, Amy Berman Jackson, has scheduled a hearing for today, and sentencing is currently expected to take place this week. So that's just the roll-up of what I think are just objective facts in the timeline, the tick-tock of the timeline. And then not only the objective facts, but Lisa speaking about this and others speaking about this in terms of the grave danger for the Justice Department in the country. So I first thought to turn to Andrew as a kind of an opening to drill down deeper into the greater complexities of the background, how the guidelines work in the situation, some of the misinformation or information that's out there.
Sure. So I'm going to bore you with some of the details about the sentencing guidelines in the initial submission made by the career prosecutors, and then the subsequent submission made by the U.S. Attorney and the Chief of the Criminal Division. As many of you know, the United States sentencing guidelines were put in place to try and give more uniformity so that like defendants would be treated similarly. So a very Aristotelian notion, and an effort was made to try and figure out all of the variety of factors that could go into a sentence and to categorize them. The guidelines currently are advisory, meaning that both sides, the government and the defense, have to set out their position on what the guidelines are, what applies, what doesn't apply, and the court needs to make a determination as to the guidelines that apply, each and every one, but the court is no longer bound by them, meaning the court doesn't have to make a finding in order to depart from the guidelines. They're advisory. But it's important that that's where the court has to start, and that the parties still make the exact same kind of submissions that they do when the guidelines were mandatory, which is you have to set out what it is that you believe. Obviously, under the guidelines and under DOJ policy, there's certain factors that, of course, are impermissible. It's impermissible to consider politics or political affiliation or who you know in the White House any more than it would be appropriate to consider race or sex or creed. So with that as a backdrop, the initial government submission, the career submission, dealt with the guidelines in the following way. The first issue is the base offense level. That is what is the guideline for the collective crimes, the 7 counts all sort of group, and the general guideline for that is a level 14. that correlates to a certain number of years. But the real issue is the enhancements. And there were 4 enhancements that the government said apply, meaning that looking at the facts honestly and dispassionately, the government thought they triggered these enhancements. One enhancement was for causing or threatening to cause physical injury to a witness. That is the one that's gotten the most attention, and that leads to an 8-level enhancement, so that's quite considerable. The factual basis for that was evidence at trial that Roger Stone had threatened a witness, Mr. Credico, in a number of ways. First, he encouraged him to take the fifth, but also to do a Frank Pentangeli, which is a reference to the Godfather movie, which was to take the fifth and to lie under oath. But it got more serious than that when he threatened him in an email saying, "Be prepared to die," and then he used a word that rhymes with seersucker in response to that. So that formed the basis of the 8-level guideline enhancement. There then were 3 2-level enhancements. One was for obstruction of Congress. In other words, that it actually impeded Congress's work, and that there was ample evidence of that. 2 levels were enhanced for the plan being extensive in scope and duration. And the government pointed out that this lasted well over a year and pointed out all the ways that Roger Stone had planned this. And then the third was obstruction of the actual investigation, which the primary evidence related to the fact that Roger Stone had violated the judge's, this is Amy Berman Jackson's, pretrial orders that were sort of modified gag orders that kept on getting more restrictive. And many of you may remember that at some point he posted I can't remember if it was a tweet or an Instagram, or I'm completely unknowledgeable about like how all that works. But anyway, he posts a picture of the judge with what clearly appeared to be crosshairs next to her head, and then testifies at a hearing in a way that the judge found to be incredible. So that led to these enhancements. That led to the advisory guidelines being listed at 87 to 108 months, which is the 7.3 years to 9 years. But it's incorrect to say that the government in its initial submission recommended that that be the sentence, because pointedly, that's just the beginning of the inquiry for the judge, and the submission in its last page points out to the judge that there are a number of ways in which the court could mitigate that sentence. So for instance, the submission by the career prosecutors says the 8-level enhancement, they say, admittedly covers a broad range of conduct. You could tamper with a witness by killing the witness, or you could threaten the witness. Those are very different things, but there's still an 8-level enhancement. And the submission goes out of its way to say, we understand that you would have leeway to modify the sentence in light of the fact that this is not the worst way in which you could obstruct. And then makes other points about there could be viewed as double counting in some of the other ways in which the guidelines apply. So that's the initial submission. The subsequent submission by the new U.S. attorney and the career chief says a number of things that are salient here. One is it points out that with a suggestion that the court not apply any of the enhancements. That would be, I never do math in public, but I'm going to make an exception. So that's a 14-level reduction if you didn't apply any of the enhancements. In addition, with respect to the legal issue of whether the enhancements apply, instead of the initial submission that said what is clear about the law, it said that these things are perhaps, arguably, all sorts of words to make it to mitigate the idea that the law actually requires any of these guidelines. The submission also says that the court should consider things that are typically and generally not to be considered under the guidelines. So it says that you should consider Roger Stone's age, health, and lack of criminal history. Well, the lack of criminal history is already factored in, so that's sort of an irrelevancy. But age and health have to be extraordinary. And I think the good news for somebody like me, I'm 61, is it turns out Roger Stone is 67. I didn't realize that age was a factor to be considered if you're only 67, but I think that is something that's the guidelines say you're not to consider. So it was striking to me that that was in there. And then finally, the sort of bottom line of that submission is that the submission says that there should be a sentence that's quote unquote far below the United States sentencing guideline advisory range, but then gives no recommendation. And the thing that's important in that is that that is against the Washington, D.C. U.S. Attorney's Office policy as to what they do in individual cases, which is that office gives individual recommendations. And having been in front of that judge, I know that judge expects it, that you give a recommendation. So the absence of it was unusual. And I think we'll be getting to this issue of many of you might think that you might agree as a policy matter with certain things in the second submission that are not in the first submission. But I think the issue here is that the things in the second submission are not done in every case. The thing that I think is most striking about the second submission is not just places where it is in disagreement with what the guidelines, the United States sentencing guidelines call for, the United States Attorney's Manual calls for, but there are things that are not done as a matter of course in any other case. So you have a problem of preferential treatment.
Thank you. So next question I just thought to start with Lisa is if you could get into the big issue of what are the major concerns here, what are the norms in terms of what the Attorney General would ordinarily do if ever being involved in the sentencing of any criminal case, or the White House. And just to maybe spark some of what you might talk about, in the piece that you wrote, you also said, quote, "If you understand the Justice Department, the damage has already been done," end quote. So if you could also talk a little bit about that.
Sure. Well, first, just to pick up on something that Andrew said, I served as an assistant U.S. attorney in the office that's at issue here for about a half dozen years in a number of different roles. And it was policy at that time to make specific recommendations to the judge and using the sentencing guidelines and using the math that Andrew laid out for us. So that was quite a striking departure as somebody who has served as an assistant U.S. attorney in that office. To your direct questions, Ryan, first, let's dispense with a few things. One, it is, and every assistant U.S. attorney or former assistant U.S. attorney and former Justice Department official I've talked to on this, it is unprecedented in my experience to have an attorney general reach in and overturn the recommendation and the position, not just the recommendation, the position that had been arrived at by the career AUSAs in this case. And I think we also need to remember something else, which is these were not four assistant U.S. attorneys kind of operating on their own. They work for a hierarchy within the U.S. Attorney's Office, overseen by a U.S. attorney who was placed a few weeks before, I think I'm getting my timing right, a few weeks before this whole event, specifically placed in that role by Attorney General Barr, who's a former official and a staffer in the Attorney General's office in the quote-unquote main justice, the headquarters building, and he was dispatched to lead the U.S. Attorney's Office. He signed off on this first memo that Andrew laid out. So you have the position of, yes, the 4 career AUSAs on the case, but it was the position of the office and backed up by the U.S. attorney. So I think we've got a whole set of discussions we should be having as to, how that U.S. attorney lets his entire team be so dramatically undercut, and we can have a discussion about that. So it is unheard of in my experience to have a attorney general reach in and overturn this and withdraw a position of the office in the way that this has happened. You mentioned the White House. We can dispatch with that very, very quickly. There is no role for the White House in this case or any other case, and in my experience, there never has been and there never should be. Is that written into law? No. Is that a matter of statute? No. It is a matter of norm and tradition going back to famously post-Watergate and a set of guidelines and processes that have been observed through Republican and Democratic administrations going back many, many years. Bob can speak to this. There's very clear ways in which the department is supposed to communicate with the White House on criminal justice matters. And all the appearances are here that those norms and those traditions have been thrown out the window. I think it's important, though, to back up here. We talk about norms, we talk about traditions. As I just said, these are not legally binding. There's nowhere set out in statute, right, that there should be no influence. But it's important to understand the really unique role that the Justice Department plays in our system. It's easy to think, well, it's a cabinet agency. It's headed by a appointee of the president who serves at the pleasure of the president. What's the big deal here? Well, the big deal is that the Justice Department plays a unique role. It is the single cabinet agency, executive branch agency, that wears, as I like to put it, 2 hats. It both is a policy arm of the president and the president's policies, just like any other agency, and should unabashedly be so, right? But it also has a unique role as an independent investigator and prosecutor of criminal cases. So what do I mean by that? What I mean is the president can and should set policy. He or she can say to his or her attorney general, it is going to be the policy of this Justice Department, of my Justice Department, that we're going to expend our resources and place a lot of resources and agents and lawyers to focus on healthcare fraud. That's going to be the avowed policy of this administration. I'm really not concerned with drug crimes. I'm not concerned with terrorism. I want to focus on healthcare fraud. A president is completely within his or her rights to say, that's the policy of this administration. Go forth and put your resources against those policies that I've articulated. What that president cannot and should not do, if we are adhering to the norms that have been observed historically, is to say, and I want you to go prosecute that CEO of that hospital, right? Within those policy priorities, the White House and the president should not reach in and dictate how those prosecutions, investigations are going. Why? Because it is fundamental to our democracy that the citizens believe that the incredible power of the investigative arm of the federal government and the power to take somebody's liberty that can be used in our criminal justice process, that power not be used to affect particular political aims or to deal with political enemies of the president or the kind of ruling political class, if you will. So that's really the 2 hats that the Justice Department wears. It's incredibly important that those norms be observed so people can have faith that the criminal justice process is not being used as an arm of kind of political retribution. And that's what's at issue in this latest episode. It is both the fact of potential political interference, but to my mind, and as I wrote in the piece that you referenced, Ryan, the appearance that what's going on here is subject to political influence or because of political influence. In my view, as a 15-year veteran of the department, I believe that that's as bad, if you will, as actual political interference, because it makes us lose faith in the conduct of our justice system.
So, Bob, do you want to kind of lead off from where Lisa had pointed in the sense of, are we just in this space of dealing with norms that aren't written down in law? Is there anything that we can grasp a hold of that would speak to legal constraints and what's at stake if we can't do that, or what are the implications for it being just norms that we become accustomed to versus actual laws?
Very good. Well, let me complicate the picture a little bit if I could, and I'll begin by saying I want to think about this in broad institutional terms and take it out of the current context and ask where might this be going, and how should we be thinking about it. And my own position on this is clear. I've written on this stone sentencing matter. I share Lisa's profound concern about what transpired here. But now I want to step back and talk about some of these questions of the Attorney General's role and the White House's role in the criminal justice process because of the president's tweeting and speaking on these topics. And that's certainly both in the repetitiveness, manner, and content of what he says, completely unprecedented. And I can't imagine what White House counsel wouldn't be squirming in his or her seat watching the president carry on in this way, but that apparently is a habit or a predilection that nobody seems to be able to break him from, even though he's heard even from members of his own party, they profoundly wish he wouldn't do it. But let me go to the other institutional actors for a moment. I want to quote to you from an attorney general of many years past who said that the Attorney General of the United States is, quote, a member of the team, necessarily partisan, unquote, and said of some of what he, the Attorney General, had opined in advising the president that it was, at the time, what he referred to as self-serving partisan advocacy. That Attorney General was Robert Jackson, the Attorney General for Franklin Delano Roosevelt. And he, as later became, of course, an extraordinarily distinguished Supreme Court justice. And along the way, while he was the Supreme Court justice, he was tapped to be the chief prosecutor at the Nuremberg trials. Probably one of the most distinguished, if not the most distinguished jurist of his generation. So what did he mean? He meant that the Attorney General does have more than two hats, certainly has the policy and the criminal enforcement hat that Lisa described, policy in that the Attorney General does represent the president's policy preferences and should, as any cabinet member would, and then a very different responsibility for the impartial administration of our criminal laws and law enforcement. But he had in mind a different two-hattedness, if you will, so we're now probably different beaks of multiple beaks of the same cap here, which is that necessarily influenced by politics in the broadest sense, meaning that an attorney general is under continuous pressure, and this has been true throughout the entire history of the office, to understand the president's political priorities. Again, I don't mean in sort of re-election sense, partisan political strategies in a kind of campaign partisan sense, but just broadly speaking, the politics of the government and the policy imperatives that the president perceives. And Jackson was known to have periodically, as Attorney General, and later in life sheepishly conceded as much, thrown a few to the president. That is to say, issued opinions that were really very unsound on the law, but that met the president's immediate policy imperatives, and in so doing, helped the president achieve a broader political agenda. So that's a problem with the Office of Attorney General, and puts tremendous pressure on attorney generals to have a vision about how to balance these multiple pressures. What does it mean to be a member of the president's team, which he or she surely is, but what constraints apply, and how does that influence the president's conduct? Obviously, in the post-Watergate period, there was more of an attempt, following what happened, including the imprisonment subsequently for his part of the Watergate cover-up of Nixon Attorney General John Mitchell, There was more of an attempt to confer upon the department or hold the department to a norm of quote unquote independence, recognizing again independent in some sense and not in another. And so today it would be inconceivable, for example, well, maybe not inconceivable, let me take that back. One day it will be maybe inconceivable that the president would appoint his or her campaign manager, as Jack Kennedy did, to be Attorney General of the United States. That's a pre-Watergate event that seems post-Watergate highly unlikely. But let me then take it to two more complicated hypotheticals, and then where I really think Barr did something that created a real disservice for the department, even giving him the benefit of the doubt on the following, that A, he claims, the wheels were in motion before the president's tweet, and the actions that the department took to intervene in the sentencing matter were taken independently of any directive to the president, who did not communicate with Barr. Let's just say that those things are true. We'll take them as Barr insisted was the case. Even so, I think he failed badly here. Let me just now give you two additional hypotheticals to set the stage for my critique of Bill Barr, and then I'll stop. First, when I was in the White House, I recall a particular indictment that became known to us, and became known to us literally within 24 hours of it being filed, because as Lisa points out, we weren't involved in the White House in scrubbing their law enforcement decisions. We might read about investigations in the paper, but it was inconceivable that the White House would take a role in trying to direct a prosecution, either to encourage or discourage one, or intervene in any particular phase of it. However, I recall specifically, and I'll tell you which one it was, the indictment of John Edwards for campaign finance violations in relation to some messy personal circumstances when he was running for president. And you will recall that he had a relationship, an extramarital relationship that did produce a child that he wanted to keep out of public view. And this became a campaign finance case, a criminal campaign finance case, because some of the support that was provided to him to help him create a dual but invisible life, if you will, had been provided to him by a couple of individuals who were also strong political supporters. And so the argument was that whatever help was provided to him to support this second family was provided in connection with the campaign in such a way as to convert them into illegal campaign contributions. I became aware of the case within 24 hours of it being filed because we had nothing to do with it, and we weren't going to have anything to do with it. I thought it was a very bad case. I thought it was a misconstruction of the campaign finance laws. I thought we would lose the case, which we did. And I thought it was a stain on the Department of Justice. Nonetheless, we weren't going to say anything to the Attorney General of the United States. We weren't going to call the Deputy Attorney General and say, what in the world is this case? Why would you do this? Why? Why would we not do that? Because the U.S. Attorney who was in charge of the case was a Republican. The defendant in the case was the former vice presidential nominee of the Democratic Party, and we were in a Democratic administration. And so, of course, on top of all the other norms that would prevent us, as indeed it always did, they always did, from intervening, the appearance would have been that Barack Obama was interceding, even in a case that absolutely justified it on the merits, to help a very senior, former distinguished member of his own party. So even if we chucked the norms out the window, we would never have done it. Hypothetical, that's not even a hypothetical, by the way, that's actually occurred. I'm not breaking any privileges because I didn't do anything or advise anybody or make any phone calls, so I'm clear under the canon of ethics. Lisa, Andrew.
I can confirm.
Thank you. You can confirm. I want to make sure that I don't want to get frog marched out of here. Okay. So number two, hypothetical, a president of the very aggressive, progressive side of the political aisle reads in the newspaper that yet another corporate executive, from his point of view, has escaped criminal prosecution for grotesque corporate misconduct that victimized many people, say, in the pharmaceutical sector, whether it's a pricing antitrust issue or whatever it may have been, maybe a drug safety issue. Enraged by public criticism that his Department of Justice has taken no action, the president picks up the phone, calls the Attorney General of the United States and says, read that article, look into it, I want something to be done. On the left, for that reason, as far as the president's concerned, on the policy merits. Presidents don't do that. Should presidents be able to do that? Well, arguably, the Department of Justice acts in the president's name, and this is where the president's personal politics and policies begin to merge into the perception of the direction that criminal law enforcement in that administration is taking. So there is a case, you could imagine, assuming that what Bill Barr has said about his involvement is true, there is a case for Bill Barr to say to us, well, listen, I thought it was completely outrageous, the sentencing memorandum. I thought that it was wrong. Didn't pay any attention, didn't speak to the president. I don't pay attention to the president's tweets, but I had to do what I thought it was right because I thought it would reflect poorly on the department for the original memorandum to stand and for the department's position in this matter to be poorly represented. If you were to assume that that is right, that he's got a case to be made, he went about it terribly. As Lisa said, he acted in such a fashion that there could only be presented to the public the appearance that the department was motivated by the president's expression of dissatisfaction with the original sentencing memo. As Andrew pointed out, that second submission raises a whole host of questions it need not have raised about the unprecedented kind of intervention here, the way in which the department made its case, whether it was on age or on the other factors that Weissman mentioned. What's missing here is any sensitivity on the part of the Attorney General to the environment in which he was operating with a president who tweets as he does, who speaks about the Department of Justice as he does, in a case involving a political associate in which he had a direct personal interest. On every count, the timing, the quality of the transparency on this issue, I don't think the Attorney General served the department well at all. I don't think an after-the-fact interview with a news network, as opposed to a formal statement from the department, from the Attorney General himself, is adequate to address these questions. I think it's really unfortunate that he put himself and the department in that position, even if he thought he was doing the right thing. So I close by saying these norms are largely post-Watergate, which you think is a percentage of our legal history. They don't really represent the lion's share of how people have thought about the role of the Attorney General, which is why I began with the quote from Robert Jackson and why I mentioned Bobby Kennedy. But they're fragile because they're not long and they come under tremendous pressure, under the pressure of an administration and its politics and the role of the Attorney General as, quote, a member of the president's team. And it is for that reason that the Attorney General has to take tremendous care to protect against these appearances and to not demoralize and drive from the department career prosecutors who don't want to have a part of a department that appears to have been politicized. So I'll close by saying there's some hard thinking. I do not think it's the last time we're going to see this. I don't think it's the last time we're going to see presidents putting this kind of pressure on their attorneys general. I don't think it's the last time we're going to see them select attorney generals who might be amenable to that kind of pressure. And the understanding we have of how these institutions are supposed to interact and what it means for the department not to be political is a little muddy, and we need to think it through before the next catastrophe occurs.
So just one kind of follow-up for anybody to grab at. Are we really in the space of this being just norms and not law, or can we at least graft onto it the take care clause of the U.S. Constitution that the president must make sure that he or she faithfully executes the law, and to apply the law unequally or to use the Justice Department to go after one's perceived political adversaries or in favor of one's political friends, one would think is actually a violation of his constitutional duties. And if that's true, then one implication might be that an attorney general actually has to say no. Like that attorney general doesn't get discretion as to whether or not this is within norms, and that the president is legally allowed to do it, though it's against the norms to do it. Is there something there?
So I'm going to go out on a limb and make a prediction with respect to Judge Jackson, if the sentencing goes forward on Thursday, that what will concern her is that sitting on her desk and the desk of every other judge in the Washington, D.C. District Court is a stack of sentencing submissions that take the exact opposite position on a whole variety of issues that are set forth in the second submission. And I could see her asking a lot of questions, whether it's embedded in due process or equal protection or just the United States Attorney's Manual to say, please justify this, like what is the policy? I could see her concern being not so much this issue of can an attorney general or even a president intercede and say, in general, I do not think we are applying this guideline correctly. because you could imagine that being a totally appropriate conversation for the Attorney General or even the White House to say as a policy matter, but that means it's applying across the board. The issue here, and the reason I think it's sort of a simpler one, is that you don't have it applying. And the reason I think you're seeing so many former AUSAs and apparently now judges being upset is this idea that there's going to be different standards for people based on who they know. And that is the kind of thing that goes against everybody. I think not just people who are part of the system, but I think Americans just understand that those are not supposed to be factors that apply. And one final point is that I think one of the things that you're seeing on behalf of the administration, most recently, Mark Short, I think the chief of staff to the vice president, saying to help justify this is that what we were trying to do was even the playing field, because there's disproportionate justice, but it happened the other way, which is, look at this, Roger Stone has been convicted and has gone to jail potentially for lying, but Andy McCabe is not. And the answer to that is the facts. So in Roger Stone's case, a jury found beyond a reasonable doubt that he was guilty of all 7 charges. And by all accounts, Andy McCabe, they couldn't convince a grand jury to find guilt by probable cause. So one is, for Roger Stone, is the highest standard known in the criminal law that a jury found, and then the other is one of the lowest standards in the criminal law that could not be met. So there's no disproportionate justice. There's an application of the facts being considered by a grand jury and by a trial jury.
I would just add to that it is not crazy for an attorney general to have a view as to how such a matter or across the board, how these matters should be handled. So for instance, I think every attorney general I worked for in my career had a charging memorandum that they articulated, and they say, look, U.S. attorneys and assistant U.S. attorneys across the country, we want you to adopt a policy, and it was different under different attorneys general, to always charge the most serious crime that you can charge in any case. That's going to be our policy across the board. A different attorney general pulled that back and said, you know what, we're going to give you some more discretion. We're not going to say you have to always charge the most serious charge that you can charge. This attorney general, by the way, reverted to the other way, right? So it's a little bit ironic, has adopted, reversed the Holder charging memorandum that said we're going to give you more discretion, assistant U.S. attorneys. I think under Sessions, I think it was, and I think Barr kept this in place. He said, no, you have to charge the most serious charge you can make. So it's fine for attorneys general to articulate that policy. To Andrew's point, it's got to be applied even-handedly. I have not done this research. I would love for somebody to do it. All you law students out there, here's a research idea. How has the Department of Justice in the last 3 or 4 years approached sentencing enhancements for obstruction when there was a capability of having an obstruction enhancement across the board? The type of math that Andrew laid out earlier in this panel, how has the Justice Department applied that and done that math in other cases across the board, right? That would be interesting to know, and what has the Attorney General's position been on that. The last point I would make is, I think there's a way, to take Bob's point, giving the Attorney General the benefit of the doubt that he thought, the math was wrong, or they shouldn't have articulated the memo in the way they did. The Attorney General would have been within his rights to say, you know what, team, let's have a meeting, let's have a discussion. I was a little concerned about how I read this memo. I'm a little concerned that the judge may read it to say that we are in fact recommending a 7 to 9 year sentence. I'm concerned about that. I'm concerned, hopefully he would say, I'm concerned because that doesn't represent a department-wide approach. to these issues. So let's have a discussion, and when you get in front of the judge, let's talk about how you're going to answer her questions in this regard. That would have been, to my mind, a completely appropriate discussion for the U.S. Attorney, the Attorney General, the Deputy Attorney General to have had with that team. That is not what happened, and what you had was this second sentencing memo, which is really outside the norms and contrary, as Andrew laid out, in some respects to how the department has applied these guidelines before.
So just to bring a brief and fine point to it, I mean, the answer to your question, Ryan, is the department's integrity. I think Andrew and I've not ever been a member of the Department of Justice. I've always been a sort of either as a defense counsel begging them not to indict a client, or alternatively, I was White House counsel and dealt with them in that capacity. But there is no legal answer to this question, at least not the way we framed it today. There is the need for exquisitely good judgment on the part of the senior leadership of the department. And I think Barr has not displayed it here. And I should mention also that the speeches that he has given, in many cases, sort of very aggressive political speeches he has given, and I'm more than happy to say that some predecessors of Barr have fallen into this trap, are not speeches the Attorney General of the United States should give. And those are speeches that ultimately do frame for people their understanding of subsequent action that he takes. But I think that if I were advising the Attorney General of the United States, I could not say in response to your specific question, oh no, sir, you can't do that. It's a violation of the take care clause, because I don't think that's a sustainable constitutional legal position. But you can certainly talk about the department's norms and the traditions, the grave dangers involved in just not going about doing it the right way. And Lisa points out there are ways you can go about expressing on the merits concerns, even in politically sensitive cases.
So I want to pick up on the idea of so broadening the aperture, as I mentioned at the outset, to other actions that the department has taken under the Attorney General, under Attorney General Barr, to think about whether or not this is such an isolated case, to think about potentially like his speeches that help frame our understanding of what might be his motivations. And if you can just anybody to start with this, maybe Andrew first, in the sense of how you've been following this, and I also understand that you would not be able to talk about matters that directly implicate the special counsel's investigation, but other matters that might be indicators of great variance from the norm. So what I'm thinking about are examples like the strange replacement of the U.S. Attorney, who is the head of the office in D.C., and now she is also was transferred to the Treasury Department, resigned. The strange flip-flop that seemed to occur with the Michael Flynn sentencing. Just to identify a few of them, the Deputy Attorney General getting personally involved in the placement of Paul Manafort in terms of where he was being sent to prison when he was going to Rikers, and then getting personally involved in that case. The Justice Department being involved in the president's tax cases, What are the other indicators?
So I'll
Yeah.
give you a little bit of color to the last few, focusing on the period after I left the department in April of last year. So first, with respect to Jessie Liu, she was the U.S. Attorney in Washington, D.C., and she had previously been nominated a while back to be the number 3 in the Justice Department, and then that was withdrawn because of, at least what I've read, was because of her membership in a bar group where the bar group was not sufficiently conservative on a woman's right to choose, and so she then remained at the Washington, D.C. U.S. Attorney's Office. She then was nominated to have a position in the Treasury Department. The normal procedure would be that she would stay in her job, and then she'd either be confirmed or wouldn't, and then if confirmed, would move over. Instead, what happened was with little notice, she was told that thank you for your service, and the current U.S. attorney was put in place by Attorney General Barr, and she was given a desk to sit at, waiting to see whether she would be confirmed. There's nothing that is, I mean, it's crass in the way it's done, especially when she was a Trump administration appointee, and it's unseemly. There's nothing illegal about that, but it's an indication, and it certainly leads to suspicions about what was the reason to remove her so quickly, given that her office was handling a number and is handling a number of sensitive matters, some emanating from the special counsel investigation. The second case that you referenced, I think, is the Flynn case, where something extremely similar happened, if not identical, to the Stone case, which was that the initial sentencing submission went in, and if you remember, Flynn was the former national security advisor. He was convicted by plea, meaning he admitted that he lied to the FBI in an interview, and he also admitted, as part of his plea, that he committed a FARA violation, a Foreign Agent Registration Act violation. After his plea, he was asked by the judge whether he intended to stand by his plea. He was placed under oath, and he again admitted that he was guilty, and then changed counsel, all of which is his right to do, and said, I, in fact, am not guilty, which, of course, is quite at odds with his statements under oath to the federal judge twice. And he then was not used in a trial in the Eastern District of Virginia, since it would obviously be very difficult to put a witness on who was not accepting responsibility and had lied under oath. And the government could take the view that he lied under oath, and was now lying to the judge after he had pleaded guilty. So the question is what to do with somebody like that. So a standard, I would say Lisa and I, if we had a cooperator who no longer was cooperating and submitted a something to the judge after cooperating that we thought was false, that person would not get a cooperation letter to the judge, and you essentially would throw the book at the person, which is what that submission did. It actually did a little less than that. It could have been harsher. It could have said he shouldn't get acceptance of responsibility. It could have said the guidelines understate his criminality, because his guidelines are for making a false statement are only 0 to 6 months. But that didn't satisfy apparently the higher ups, and so there was a revised sentencing submission that said we got it wrong, and we still are recommending probation for this defendant, which had been the initial recommendation before all of the Sturm und Drang about whether he was wanting to withdraw his plea or not. So that is really similar to what happened in Stone, other than you don't have, obviously, the people in the Justice Department resigning. And then the third thing, which is, I think, a smaller issue, but it is similar because of the issue of disproportionate justice, it's sort of people not being treated similarly, is that when Paul Manafort was brought up to the state of New York to face state charges that were brought here, there was an issue about where he would be housed. Typically, a person is brought up here and they're housed in the jurisdiction and in the jail in which of the location, so that he'd be transferred from federal custody to state custody and then brought to court. That's sort of the normal procedure. And here, one of the first acts of the new Trump administration Deputy Attorney General, brought in by Attorney General Barr, was to reach out to have the accommodation made that Mr. Manafort would be housed in federal prison here, not in state prison. And just to be clear, there's nothing wrong with that. And frankly, I might think that's a really good solution, because there's no reason to subject someone to state custody, if they could be in federal custody. The issue, though, is not that. It's just like my point, at least with the Stone case, which is it's not the substance of it, it's that it's disproportionate. My question to the Deputy Attorney General is, what is the procedure for every African-American defendant who faces that? Do they get the same treatment that was given to Mr. Manafort or Mr. Stone or Mr. Flynn?
One of the things that I worry about, I should mention two things. So McCabe, the department decided not to prosecute Andy McCabe, and the department also shut down the Clinton email investigation. One of the concerns you might have is, well, maybe Bill Barr is just trying to manage Donald Trump. He's basically giving him what I'll call an emotional snack from time to time, but then ultimately giving himself space to do something like walking away from the McCabe prosecution, walking away from the Clinton email investigation. But the problem is the one that Lisa identified, that if you do it the wrong way, you may be managing the president, and there may be some outcomes that you can achieve that you otherwise would have difficulty achieving, but the damage you're doing along the way is not easily repaired.
Just to echo that, there's been a lot of discussion about and psychoanalyzing the Barr ABC interview that Bob referenced. Headline, I'm sure we all got a barrage of alerts on our phones when Barr did this interview the other day. I thought they were a little overwrought, the headlines that he's taken Trump to task, that he's, conflicted finally with the president, et cetera. But in none of that interview was there any statement about the institution. There was no discussion about standing up for the AUSAs who were doing their job and, again, need to underscore, doing so with the approval of their chain of command in their office, the U.S. Attorney. The entire interview was about how the tweets make it difficult for Barr to do his job, which I have no doubt is true. But what was, I think, really missing from that interview, if indeed it was designed to shore up the building, as we say, and some of the psychoanalysis of that interview was that he had to go out and make some kind of statement or give some type of interview because he was, quote unquote, in danger of losing the building. I'm not sure that interview mitigated that concern to the extent he had that concern, precisely because there was nothing present in that interview that stood up for the line AUSAs. These are the frontline prosecutors who were doing their job.
So we have time for some questions from the audience, maybe starting with some NYU students.
I'm just curious about the recent memo that Attorney General Barr issued last week, kind of requiring that the opening of any investigation of a presidential candidate be run by him, or an investigation of campaign staff and potentially illegal foreign contribution. I'm just wondering what the impact of that will be, and also to your point about norms, whether this is normal.
So I'll start on that. I've actually said when that first came down, it was a recommendation coming, I believe it was a recommendation coming out of the IG report. There was a review of the beginnings of the FBI's Crossfire Hurricane investigation into Russian interference in the 2016 campaign. One of the recommendations coming out of the IG report is that investigations of such moment, of such significance, such as an investigation into a presidential campaign and into a sitting president, ought to receive higher level approval and awareness within the FBI and the Justice Department. In the case of the Crossfire Hurricane investigation, I believe it was signed off on by the head of the FBI's counterintelligence division. And the IG took issue with the fact that something of that significance did not receive clear approval and briefing to the FBI director and to the AG. My own view, and this is somewhat controversial, is I actually agree with the recommendation from the IG and agree with the what Barr said, which is that going forward, these types of investigations ought to be signed off on by the FBI director, by the DAG and the AG. Now, you might say, well, Lisa, you just spent the last hour saying there shouldn't be political influence in these investigations. My view on this is that political appointees are politically accountable, right? So the Hill should call up the Attorney General and say, well, you did or you didn't sign off on X investigation into this political candidate. What is your, what's your rationale for that? It is not to say that the political appointees shouldn't be doing their jobs. They absolutely should be. And there has to be some transparency to that, and only in holding the politically accountable individuals accountable can you have that transparency.
So I basically agree, but I thought that the Attorney General did something smart, but not exactly smart in the terms of the goal he was trying to accomplish, I think, but I didn't think was the proper way to deal with this. When the FBI, for instance, has to open sensitive matters, there is a review process, but that review process first starts with an apolitical committee of career agents. And I think what was missing from the Attorney General's announcement is I think it was fine to take up the what it is that the IG found, but it should have put in a lot more process to make sure that there were career recommendations and had been vetted by career people. That way, in terms of the political accountability of what the Deputy Attorney General or the Attorney General does, there's a record that they get from the career people as to exactly what they think. So it also makes it a little harder to overrule it. And then, the person has to account for why they then did or did not, and as to whether it was a political reason or not.
Any questions?
Yes.
I do think we were talking about this a little bit briefly before we started here. This is why I think stepping back and trying to figure out where we're going is important, because I don't think this is going to turn out to be a one-off experience. I think you see in our political system today on both sides of the aisle, expressed in different ways, different levels of intensity, a corrosive distrust of institutions and a lack of respect for norms, a belief that norms serve essentially to seal in power differentials, to help, if you will, some sectors of the economy or the society to the disadvantage of others. And therefore, an appeal to norms isn't necessarily very convincing to people. They think, oh, I know what your norms are all about. I understand why you're asserting norms to me. When you have that level of collapsed trust, and it's sort of deeply woven into the political moment, then I think you're going to start seeing expressions of this from all different directions. I'm not suggesting, by the way, that everybody, we're going to see Donald Trump type people with that particular leadership style popping up all over the place. But I think we're going to see some of these broader themes repeating themselves. And the question is how do we get that back? I'm going to just drop one complaint here a little bit. After Watergate, actually during Watergate, the American Bar Association was extremely vocal, right? In the wake, for example, of the Saturday Night Massacre, after President Nixon had fired independent prosecutor Archibald Cox, the American Bar Association issued a statement as an organization criticizing the president and calling for an independent prosecutor to replace Cox. I can't recall exactly how it was framed, but it was an organizational statement of protest. There was a sort of civil society response, if you will, in sectors where you would expect that sort of leadership to be exercised. Now, in the wake of the Roger Stone, it's so far, up to this point, we haven't really seen very much of that.
Well, you do have 2,000 former AUSAs.
I was about to say, up to this point. Up to this point, you're starting to see a little bit of that. And there's apparently some meeting of the Federal Judges Association to take this up. So which by the way, may be concerned with some of the issues that you raised about how they can do their jobs under these particular conditions. But think about the entire period from 2017 to the present, right? How much sort of formal, if you will, civil society leadership on these particular issues has been asserted. And I think it's very telling that it hasn't been. And I think that's because there are just deep disagreements in a polarized political society about sort of where that consensus actually lies, how that consensus can be identified and expressed. So I do think it's a deeper problem.
One fact that stood out to me through all of this is the fact that this is happening in the DC U.S. Attorney's Office. And I think it was, Lisa, you mentioned that there was the U.S. Attorney now is a recent appointee and was a former close associate of AG Barr. How important is that fact in this? And would you say that that means that other U.S. Attorney's offices around the country, over 90 of them, are more insulated because of that, because there might not be that close tie, and might that weigh in favor of stepping back from the system of political appointees filling these roles?
So, I think it's interesting to see some of the reporting that has come out in the last couple of days of U.S. attorneys, political appointees. U.S. attorneys are, of course, appointed by the president, confirmed by the Senate. And there's been a series of reports that I've seen, at least, of U.S. attorneys who have sent notes to their office, made statements to their teams, their office saying, we're going to continue to do our jobs, right? So what you're seeing is small acts of, I think, some U.S. attorneys trying to say, look, we're going to continue to keep our heads down and try and do our jobs. Now, that's only as good as, the next very politically sensitive case they get, and they may end up being on the wrong side of a tweet storm, right? So I think at the end of the day, U.S. attorneys, like, unfortunately, a number of AUSAs, are having to be put to their own personal tests and to decide, where are their lines and, where are they going to stand, and are they going to stand up for the institution?
So I have 2 points that are sort of a pro and con, which is, so it's hard for, I think, any U.S. attorney to take too much solace given that Jesse Liu was removed so abruptly and a new U.S. attorney put in the same day. On the other hand, the U.S. attorney in D.C., and this is true for other U.S. attorneys, I think it's true for Jeff Berman, if there's no confirmed U.S. attorney after a certain amount of time, the selection is by the judges. So if there is not a confirmed U.S. attorney in D.C., that is then going to be the judges in D.C. are going to choose, which will be fascinating in D.C. in light of what just happened. And I'm pretty sure in the Southern District, Jeffrey Berman has been chosen by the judges and is not a confirmed U.S. attorney. I'm not positive, but I think that's right.
I think we have time for one last question.
I have a question that's partially hypothetical and partially real. What is the impact on the justice system throughout under the Attorney General and all the AGs across the country of pardons by the president? Hypothetically, there could be a pardon of Stone. There could be a pardon of Manafort. While we're sitting here, the president pardoned an ex-NFL team owner for a felony. What's the impact on cases brought by the Justice Department in seeing things that they really don't think should be happening?
I mean, on the one hand, you can imagine a number of AUSAs thinking, like, why am I going to go forward bringing these cases if at the other end there's just going to be a pardon? I think for the most part, AUSAs are, well, you can't help but confront that current reality to just a few of the ones that you mentioned. That is kind of staring them in the face. But by and large, I think the impact is yet to be seen, right? The resignation of the withdrawal, rather, of the 4 AUSAs last week and the full resignation from the Department of 1 is the reason so many of us have been so stunned by that is because it's really the first time we have seen this type of reaction from our former colleagues. But I think we'd be naive to think that folks who are, quote, on the line aren't looking down the line and saying, the pardons could well be forthcoming. To my mind, I don't understand why the president, I'm shocked, frankly, that the president hasn't pardoned Stone at this point, given, or Manafort, right? Or Flynn, for that matter, for all the toing and froing that's been going on.
The one thing I'd just remind people is that this wouldn't be the only president who people think may have misused their pardon power. I mean, it's happened in the past in ways that I think people in the department think, undermine the rule of law. It's a very unusual power in terms of, it's where it derives from and how it's implemented, because it doesn't have all of the processes around it that you would want to see to make sure it's not abused. But it really wouldn't be the first time.
And on this one, I might take a little bit more of a hard line than others. That is to say, how the department senior leadership would respond. Andrew's absolutely correct about prior controversial uses of the pardon power, and there have been congressional investigations about pardon abuse as recently as the Clinton administration in the wake of President Clinton's sort of pardons in the 24 hours before he left office. But given this president's public record, what he has said about the control he would like to exercise of the Department of Justice, his calls on the Department of Justice to prosecute political enemies, his intervention now, for example, in the Stone sentencing, and we could obviously cite any number of other cases, repeated attacks on the Mueller investigation and their motivations. It seems to me that pardons that are issued in this space right now by this president ought to concern this attorney general. And the president can go ahead and do it. I mean, there's no question the president can do it. But I think that the people who are responsible against this particular background of this president and this administration for rule of law issues ought to be making it very clear that there are some red lines that would precipitate resignations if the president decided now, on top of all of that, against this particular history, to start issuing pardons to witnesses. And, excuse me, not just witnesses, I'm sorry, to the convicted.
So please join me in thanking this extraordinary panel.